Listen to this Vinita Singh clip first and then I'll break down the law on it.
तो हमने पहले से ही जिस दिन हमने डिसाइड किया कि हम एक साथ काम करेंगे, हम एक फ्लाइट में थे एंड आई रिमेंबर हमने वहीं पे एक टिश्यू पेपर लेके एक कॉलम बनाया सेइंग दैट दिस इज लक्ष्मण रेखा, दीज आर द थिंग्स जहां मेरा फाइनल कॉल है, दीज आर द थिंग्स जहां कौशिक का फाइनल कॉल है। तो मतलब अगर लाइक फॉर इंस्टेंस प्रोडक्ट पे मेरा फाइनल कॉल है तो कौशिक कितना भी डिसएग्री करे कि नहीं ये ऐसे होना चाहिए, मैं पॉइंट ऑफ व्यू सुनूंगी बट आई कैन स्टिल डिसाइड।
Now, this is actually very common amongst co-founders when on certain issues one founder wants his decision to prevail. And the best way to avoid any kind of disputes in such a situation is actually to put it on paper. Not on a tissue paper, but on an actual paper in the form of a co-founders agreement or a shareholders agreement. But there can also be cases where the co-founders want a reverse of it, where they can want that certain issues have to be decided and have to be agreed by all of them unanimously. And this is something that I recently faced as a corporate lawyer dealing with a company where there were 5 co-founders. And they were very clear that on certain issues, they will not agree with a simple or even a special majority. They want complete unanimity in the decision. And unless there is complete unanimity, they do not want to move forward in the capacity of a shareholder. So how we resolved it was that when we were drafting a shareholders agreement for them, we created a list of reserved matters. And therein we put in all those matters on which they required unanimity, and we clearly provide that the resolution cannot be passed unless all of them agree, which basically is in a way providing veto to each member. And then in order to ensure that this remains legally binding on the company and all of them together, we also made amendments into the article of association that is extremely important if you want these things to be enforceable.